when it's your turn.
Let's go.
Honorable Justices of the International Court of Justice, my name is Giovanna Macharya, and I represent the Republic of Belarus in this appeal challenging the legitimacy of criminal indictments issued by the United States Federal Court against 4 Belarusian officials. These indictments, filed in January 2022, allege conspiracy to commit aircraft piracy in connection to the diversion of Ryanair Flight 4978 on May 23, 2021. Yet they raise troubling questions about jurisdiction, legal identity, and the integrity of international law. The alleged offenses occurred in Belarusian airspace under Belarusian authority and involving Belarusian nationals acting within their own official capacity. The United States asserts jurisdiction based solely on the presence of 4 American citizens aboard the flight. This appeal calls for the court to reaffirm the principles of sovereignty, due process, and legal restraint. The issue before this court is whether the United States may assert criminal jurisdiction over foreign officials acting within their own sovereign territory, and whether indictments lacking legal identity and enforceability meet the standards of international law. Honorable Justices, the argument presented today is not merely academic. They are relevant, foundational to the credibility of international law. We're not asking for this court to defer the conclusions of another nation's jurisdiction. We're simply asking for de novo reviews, a fresh, independent examination of the facts, the legal standards, and the jurisdictional claims. This court must revisit the facts in its entirety, not through the lens of a domestic court's assumptions, but through the principles of international law. The legitimacy of this appeal rests on the understanding that no single nation's legal system can direct what is right or wrong for another sovereign state. The rule of this court must be universal, not unilateral. Each argument we represent sovereign jurisdiction, legal identity, statutory relevance, and symbolic overreach, and that is grounded in the precedents and principle. Together, they form a cohesive challenge to the notion that one country's court can extend its reach across borders without consent, clarity, or consequence. This is not about Belarus. It is about the future of international corporations, the credibility of global justice, and the protection of sovereign legal systems from politicized prosecution. The court's de novo review is essential to restoring balance and reaffirming that justice must be principled, not performative. On May 23, 2021, Ryanair Flight 4978 was diverted to Minsk under Belarusian aviation protocols. 4 Belarusian officials acting within their official capacity were later indicted by U.S. federal court. 2 individuals were improperly identified, one listed as first name unknown, last name unknown, and another without a surname. Belarus has refused inscription, and no trial has occurred. Our first argument is a violation of sovereign jurisdiction. Our legal precedents are Corfu Channel case on 1979 and the United States versus Alvarez Machain on 1922. This argument proves our point by showing the U.S. has overreached. The Ryanair incident occurred entirely within Belarusian airspace, and the actions were lawful. Under Belarusian jurisdiction, the U.S. indictments bypass diplomatic channels and violate principles of territorial sovereignty affirmed in Corfu Channel and challenged in Alvarez, Michigan. Why is this argument superior to the status quo? The current principle, where a powerful nation asserts jurisdiction beyond their border, replaces cooperation over coercion. Our argument restores balance by reaffirming sovereignty and demanding lawful restraint. This court must hear this case now to prevent a precedent that erodes territorial integrity and invites global instability. Our second argument is a lack of legal identity in the indictment. Our legal precedents being Handy versus Ramfield on 2004 and prosecution versus Thomas on 2012. This argument proves our point by exposing procedural failure. Two indicted individuals were improperly unnamed, one listed as FNU and LNU, another missing a surname. These omissions violate both US and the international relations process. Why is this argument relevant to the status quo? The status quo tolerates vague indictments and compromises individuals' rights and jurisdictional credibility. Our argument demands precision, transparency, and fairness. This court must hear this case now to reaffirm that justice begins with identity and that due process is not optional. If there are no further questions, I will sit, retire, and my partner will now come and do the second speech. We pray that you vote sovereign immunity and allow a country to have power over its own country and to vote for the court to hear the entire case before the full court.
Thank you.
Honorable Justice of the International Court. My name is Elisa Pina, and I represent the Republic of Belarus in this appeal challenging the legitimacy of the United States Federal Court issued indictments against 4 Belarusian officials. These indictments, filed in January 2022, allege conspiracy to commit aircraft piracy in connection with the diversion of Ryanair Flight 4978 on May 23, 2020. Yet, they raise troubling questions about jurisdiction, legal identity, and the integrity of international law. The alleged offense occurred in Belarusian airspace under Belarusian authority and involved Belarusian nationals acting on their official capacity. The United States asserts jurisdiction based solely on the presence of 4 American citizens aboard this flight. This appeal calls on the court to reaffirm the principles of sovereignty, due process, and legal restraint. Please cross-apply my partner's arguments and then add these 2 additional arguments. Argument 3, no violation of US law by Belarusian officials. Our legal precedent, Barcelona Traction in 1970. Explanation. This argument proves our point by showing that the US lacks standing, that Belarusian officials acted within their own jurisdiction and under their own laws. No US statute was directly violated, and without a treaty-based framework, the US cannot prosecute foreign officials for domestic actions. The status quo allows nations to stretch their legal reach based on political interests, not legal connection. Our argument restores clarity and judicial discipline. This court must hear this case now to prevent the erosion of legal standing and the misuse of criminal law as a foreign policy tool. Argument 4, symbolic charges undermine legal integrity. This argument proves our point by revealing the deeper danger of politicized legal action. The indictments are unenforceable. Belarus has refused extraction and no trial has occurred. These charges serve no judicial function. They are symbolic gestures that distort legal norms and risk becoming tools of narrative control. The status quo permits symbolic prosecutions that serve political ops rather than legal outcomes. Our argument insists that justice must be real, enforceable, and principled. This court must hear this case now to protect the integrity of international law from becoming a stage for performative diplomacy. Honorable Justice, the Ryanair incident deserves scrutiny, but scrutiny must be grounded in law, not politics. The United States Federal Court lacked jurisdiction, violated due process, and indicts individuals without legal identity. These actions undermine the credibility of international justice and set a dangerous precedent for sovereign relations and legal cooperation. Our 4 main arguments: violation of sovereign jurisdiction, lack of legal identity and indictments, no violation of US law by Belarusian officials, the symbolic charges undermine legal integrity. Our value was de novo review, a full and independent reconsideration of the facts and legal standards. This is important because it affirms that no domestic court, regardless of power or influence, can dictate international norms without scrutiny. A de novo review ensures that this court does not simply inherit the assumptions of another system, but instead applies the principles of international law with impartiality and rigor. Our legal foundation was built on the respected precedent, the Corfu Channel case, the United States versus Albanian Machine, Hamdi versus Runsfield, and the prosecutor versus Thomas Langbang-Dilo. Barcelona charge. The major issue before this court today has been, can one assert criminal jurisdiction over foreign officials acting within their own sovereign territory based solely on the nationality of the passengers aboard the diverted flight? Is it important to rule the favor of Belarus today because failing to do so would legitimize extraterritorial prosecution without consent, clarity, or enforceability? It would invite selective enforcement, politicized indictments, and the erosion of sovereign legal system. The Ryanair incident deserves scrutiny, but scrutiny must be grounded in law. The U.S. federal court lacked jurisdiction, violated due process, and indicted individuals without legal identity. These actions undermine the credibility of international justice and set a dangerous precedent. We respectfully request that the court recognize the jurisdictional overreach and recommend dismissal or referral to proper international mechanism. Let us reaffirm that international law is not a tool for convenience. It is a covert principle. Justice must be principled, not performative. We pray that you apply our legal precedents, logic, and arguments to reach the conclusion that is this case before you today must be decided in an international court and not the U.S. federal court. We assert that it is justice for the individuals involved and fits into the legal rights for the countries represented today. Therefore, the only conclusion you could reach today is to allow the entire court to hear this case as soon as possible.